Awesome. Cyrus, shall we begin?
Let's do it.
All right. So, hello everyone. Thank you so much for joining. My name is Simon, and I'm with HOA Simplified. Thank you to all board members who joined us today. Today's webinar is focused on California HOA laws and compliance. We'll hit topics such as AB 130, which is a pretty hot topic, SB 326, and their impact on sales, and the current insurance market for associations, and finally, practical, some guardrails, some guidance just for our board members. And I'm really happy and thrilled to be joined by our guest, Cyrus Koochek, who's from SwedelsonGottlieb. Cyrus currently advises associations across California and contributes extensively to the HOA industry education. Just a quick housekeeping note. If time permits, we'll close with a brief Q&A. It would be great if everyone could keep the questions general and suitable for a public forum. So no association-specific questions today. So thank you guys again for joining us. So let's get started. Cyrus,
Okay.
floor.
Thanks. Let's do it. I appreciate it. So welcome everybody. I really appreciate you being here this afternoon or tonight. You're all volunteers. We recognize that. We know you have jobs. We know you have lives. So, we appreciate that. As legal counsel to associations, our role is to protect associations, protect their legal well-being, and protect their financial well-being. A little bit about me, just kind of more so about my firm, is that we only represent HOAs. So I always like to make that clear to everybody. We don't represent homeowners in HOA disputes. We don't represent management companies. We don't represent board members individually. We represent the corporate entity that is your HOA. Of course, that means we work with the board of directors, but our goal is to do what's in the best interest of the association. And I know a lot of attendees here tonight are from smaller associations as far as number of units or kind of population wise. And, a lot of people think, oh, well, that might make things easier. It can also, it can quite often be the opposite. When you have smaller associations, there's maybe more of a propensity that things have been informal for a longer period of time, or maybe historically, and then all of a sudden, one person or one situation kind of occurs and it creates unrest and it kind of upends the apple cart, so to speak. So we're going to kind of get into a lot of things, and you don't need to see my picture. I'm right here. So, okay, I'm going to start with the hot topic that Simon mentioned, which is AB 130. And of course, if there are any questions on this kind of topic appropriate, just shoot them over, and Simon will be monitoring that. AB 130 is one of the most significant changes in HOA law in about 15 years, which is about how long I've been practicing. I think everybody's pretty well aware, if you've heard of it, that, basically the state legislature, kind of under the cover of darkness, basically overnight, adopted a major budget bill. Now, that was not under the cover of darkness, but what happened kind of overnight was that the budget bill, which was a statewide bill, kind of snuck in a couple HOA related items. One of those are changes to the civil code dealing with fines for HOAs. And the kind of short and sweet of it is that there's now $100 cap on monetary fines. So if there's a violation of the governing documents by homeowners, now there's a $100 cap. The good news, I guess you could say, is that there's an exception recognized under this statute, under the change, where if the violation has a health and safety impact to the community or to other members, we are not constrained or restricted by this $100 fine. So it's, I think what a lot of boards are doing right now is evaluating their existing fine policies and fine schedules and thinking, hey, okay, we're now capped at $100 for a large kind of portion of fines that we're allowed to impose. But what constitutes a health and safety violation? And what can we do to kind of, I don't want to say circumvent, but what can we do in good faith to say, hey, some things might be health and safety related, even though it might not be something that we just kind of all think of, as life in danger, for example. Is something pet related potentially a safety issue? If a pet kind of charges near somebody, or how you're driving in the community, or smoking situations, or things that might impact somebody's mental health. if there's recurring kind of conduct all the time, maybe coming from one unit. And so I think there's going to be a lot of discretion, a lot of gray, a lot of flexibility. I think a lot of associations, based on my conversations with a lot of associations, is that they're going to be looking at health and safety violations pretty liberally to see, how can we enforce things? Because I think what the state legislature kind of misses here is, the state is very homeowner friendly, and it's kind of increasingly becoming even more homeowner friendly. But what they're missing is that HOAs are made up of homeowners, right? So like it's not just one owner who might have a dispute with the HOA. The HOA is made up of owners, and those owners care about the rules in the community because you all want to have a kind of a harmonious living environment. So it is really important to, I think, I don't want to say test the limits, but work with your legal counsel, work with management on understanding where can we go with this? Where can we kind of expand things? What can we consider health and safety related? And I think you should be open to it. There might be some attorneys who are very conservative in this. Our firm isn't. We think you should really evaluate and kind of explore what's flexible here, on what could be health and safety related. A couple things on this statute that are kind of unique or I think worth pointing out. Uh, for the first time, the board is now required to make a determination that a violation is health and safety related in an open session board meeting. So you're actually supposed to do that in a meeting that homeowners are allowed to attend. We don't like that because we think that there are privacy concerns. We don't want the board discussing a violation or a particular homeowner's disciplinary matter openly. We want that in executive session. So, this is a statutory requirement now, but our guidance is still, if you're going to be doing this, which you're supposed to now, don't refer to the homeowner's address or their names. Use some kind of account number that management might have, or just like an APN number, which you'll have for their unit. APN numbers are technically those are public numbers. So those are available kind of publicly speaking, but they're not readily accessible to most owners. So, we just want to kind of protect the confidentiality or the privacy of any disciplinary dispute with a homeowner. So keep that in mind. I think if you're not fully versed or aware of all of the changes with AB 130, let management know, but you're probably going to have to seek legal help on that. Whether that's changing your existing fine policy, adopting one if you don't have it, or just kind of getting an understanding of where you can go with certain things now. So I think that's important. Another couple important issues to address: continuing violations. This is becoming a really kind of like like a secondary hot topic on top of the hot topic, which is AB 130. And that's because the statute says, well, it's $100 fine per violation for non-health and safety violations. Well, what do we do for continuing violations? What if somebody, is renting out their unit illegally or improperly, or they paint their door a color that's not allowed, and it's just a violation and it's continuing? Well, the statute technically says it's $100 per violation, which I think most people are interpreting as kind of taking away the ability to impose ongoing, continuing violations, at least for the non-health and safety violations, the ones that are $100 per violation. So again, something you'll have to discuss with your attorney, but that seems to be what the prevailing view is on that part of the statute. So that's unfortunate, but we have to consider that the statute is pretty clear that the $100 per violation language it's per violation. So it kind of takes away a lot of the ability to just impose continuing fines. Again, that's for the non-health and safety violations. Right to cure. Now the statute says explicitly for the first time that if somebody commits a violation, that they have a right to cure it before the hearing that you call them to. And if they cure it before that hearing, you cannot impose a violation or a fine, or impose disciplinary action. So that's a first. And, this begs kind of the question, well, can everything be cured? What if there's a parking violation and they park somewhere where they shouldn't, and then they move their vehicle a day later? Did they cure it, or did they commit a violation and a day later they just moved it? So that's going to be another kind of really difficult gray. That's probably the most gray area here in the statute, personally, what I think. But I don't think everything is curable. I don't think just because somebody commits a violation, if that violation, by its nature goes away the next day because they move their car or something like that, I don't think that necessarily means it's been cured. A lot of violations are going to be singular in nature. They're going to be one-offs. And I think that, we have a right to say, well, you didn't cure it. You committed the violation. Now it's no longer a violation because it's a new day, or, the circumstances have changed, but you didn't cure the violation. As opposed to maybe painting the door of the front door of your unit pink, and that's an ongoing violation, and you cure that. So I think there's a lot of wiggle room there as well. So that's going to be a lot of this. Unfortunately, we think that this is going to result in a lot of increased litigation, because a lot of boards are just not going to have a lot of other enforcement options if they really want to kind of send a message. And I don't mean that just to say send a message, but if they don't have a lot of avenues to enforce the governing documents, which all of you board members have a legal duty to do, you have a responsibility to enforce the governing documents. So you're supposed to be enforcing. Do we want you to litigate minor kind of violations? No, no, we don't. But, there might be some that are more serious, like rentals or architectural items, or even health and safety items, where, you might be left with no choice but to kind of escalate things. So that's going to be an unintended consequence, and we just have to be aware of that. Couple other things on AB 130 before we shift topics. And I'll just spend just a brief minute on this. One other thing that nobody's really mentioning or talking about under AB 130 is some language that changed what HOAs can do with ADUs. And a lot of you here today might not live in communities where ADUs can even be, constructed. ADUs can basically be constructed in planned developments where owners own an individual lot of land. But a lot of communities in LA and kind of the greater area in general, not all communities have to be kind of large rural estates that kind of allow for large lots of land. There are some communities that are zoned or kind of are designated as planned developments, but they might be more townhome style, and they might be kind of not the norm that you might consider for, hey, can an ADU even go here? So something to keep in mind regardless is um, part of this law changed. It basically restricts HOAs now from imposing fees against ADUs. And so a lot of people are seeing that and saying, oh, we can't impose any fee now. A lot of HOAs were actually considering imposing assessments against people who construct ADUs, because it's going to result in more people. There might be a greater impact on the common areas, maybe on the amenities. And so we're thinking, okay, we're going to impose fees or assessments on the people who have an ADU because of just the actual impact to the community. That's going to be difficult to do now, because the language of the statute has basically added a specific or explicit language that now says associations cannot impose fees that are ADU related. But I still think there's some wiggle room here, because I interpret that very narrowly. Um, I think if you're imposing a fee against somebody just because they have an ADU, that's a no-no. But if you have architectural processes, like application fees, or our expert fees for evaluating something architecturally because there's structural, construction involved. So I think those kind of fees that you otherwise still charge on any other kind of improvement in the community, I think those can still be imposed against an ADU or somebody with an ADU. So I just wanted to mention it, flag it. You don't need to fully understand it, but you should just kind of be aware of it. So if somebody is submitting an application for an ADU, you have this in mind. If you are in a community with the potential for ADU construction, you should have an ADU policy. That's a must. And if you don't have one, people are going to, they're going to seek installations and they're going to say, well, you don't have any rules governing this. Your CCNRs don't address it most likely, especially if they're outdated or older, and you don't have any rules on it. And, then they'll claim, that if you try to impose certain rules, that you're acting arbitrarily and you're just kind of coming up with something out of thin air. So important that you have something documented in writing. That's always the best protection for our boards and our associations. All right. Any comments on that, Simon, before we move on to the next topic?
Yeah, I mean, AB 130 is obviously you just said it's a pretty hot topic, and actually kind of you brought up privacy concern when you were talking about the fines. So I think it'd be helpful if you could just like give us a quick rundown on actually what should be discussed on typical just like a meeting with homeowners versus like a executive session.
Right. Yeah, that's a good question. So I think the majority of everything taking place with a disciplinary matter should be an executive session. And, a lot of people probably don't know this, but technically, the statute actually says that disciplinary hearings are supposed to be held in open session unless the member requests executive session. But nobody does that. Everybody holds disciplinary hearings in executive session. And that's my recommendation. And that's what I'm familiar with. Even other firms, everybody kind of gives that guidance. Um, because the statute introduces a new issue here, which is if you're going to make a determination that an owner's violation was health or safety related, you have to do that explicitly in an open session meeting. And that's really all the statute says on that. So my recommendation is the hearing itself will remain an executive. You're still going to call an owner to a hearing, same process as you would normally have, and you'll hold the hearing in executive, either before your executive session hearing or after it. You're going to need to have an open session. It doesn't necessarily have to be the same day, but either before or after it, you're going to have to hold an open session meeting. And during that, you'll have something on the agenda that will basically address disciplinary violations. And you'll just have to make a very general determination that, hey, with respect to a particular violation, again, we're not going to identify them by name or address, but with respect to this violation, we're hereby making the determination that it was health and safety related for X, Y, and Z reasons. And it could be very simple. We believe that they were driving 20 in the garage and, there was somebody walking and that posed a threat of safety in the garage. And therefore we consider that a health and safety related violation. That's it. End of story. It'll be addressed during the hearing. So very kind of broad strokes. And that's pretty much it. You have to do that either before or after the hearing. And the reason is, one, the statute says so. But number two, you can't technically impose the fine or the disciplinary action you're imposing unless you do that in open session. So that's a part of the process procedurally in order to be able to actually impose your fine or impose your discipline. So that's the process kind of in a nutshell. One other thing real quick, suspension of privileges is one thing I didn't mention, which you should all be considering. If you have amenities and you're able to suspend privileges, you're still able to do that, and you should consider doing it. There are a lot of situations where a homeowner might have a tenant. They use the amenities a lot. That's a big kind of feature or characteristic of their enjoyment in living in a particular community. And, I have associations that they disable the fob access to the amenities. Or, if you have a gate and you allow guests to be kind of allowed through the gate, you might disable that kind of option or that kind of functionality. And you might say, hey, you have to go retrieve your guest directly. And that's a big inconvenience to you, but guess what? That's a privilege we're suspending. So there are some kind of, useful and potentially, kind of impactful suspension of privileges type disciplinary measures that you could also implement. So that's something else to consider. Again, if you're going to do this, you have to have that in your fine policy. So that should be addressed in your fine policy.
Super helpful, Cyrus.
Sure. Okay, so next topic, we're moving on to guardrails for board members. And these are just kind of some I think, big ticket, um, present day kind of tools that will help prevent or protect you as board members. And again, as legal counsel, we want to limit the liability of the HOA. And in line with that, we want to limit the liability of the board members. And if board members are enforcing the governing documents properly, doing what we call exercising sound business judgment, if you're exercising sound business judgment, you're going to be protected as board members. And kind of everything you see here on this slide, which I'm going to touch on, ensures that you're protecting the association and that you're acting as fiduciaries, meaning you're exercising sound business judgment. This all kind of goes hand in hand. In a nutshell, you have fiduciary duties to the HOA. That means you have to act in the best interest of the HOA, not yourselves. The best way to do that is to exercise sound business judgment. There's actually a California Corporations Code provision that codifies that business judgment kind of idea. It's kind of a corporate speak type kind of idea nationally, but it's actually codified in a statute here in California, which is good because then you can point to it and say we're complying with the statute and therefore we're protected as board members. And minutes is kind of a very kind of specific one that we're pointing out, but it's important because we get a lot of issues that actually surprisingly relate to minutes. And a lot of boards, especially boards that might not have a history of having guidance professionally through management and legal counsel, they kind of want everything laid out in the minutes. They want it to be a transcript. They think that protects them because it's overly transparent. And we actually say it's quite the opposite. Your minutes should reflect a record of the items, the action items that were taken during a meeting. What items were acted upon should be pretty straightforward. You have an agenda. You might have a contract on the agenda that you're reviewing and maybe approving, and the minutes should reflect that you reviewed and approved the contract. You don't need to go into detail about, well, this board member said X, Y, and Z. That was countered by this member who brought up this point. You don't need to go into that. And one, it's not really productive. Two, we care about the liability here. We don't want there to be a transcript from a litigation standpoint later on if somebody says, well, you guys made a decision, but there was a lot of opposition to it. And, there was counter views by the board, and he actually said this, and then she said this. And this is contrary to maybe something that the board was saying otherwise. There's a lot of things that can kind of just come out of this. So we say minutes should be minute. And that's kind of the little catchphrase that we like to just kind of hammer home with our boards. So I would say make sure your minutes are reflective of your agendas. So, you want everything kind of in there. Also, most board meetings, technically speaking, you're supposed to hold a homeowners forum where homeowners get a chance to kind of speak for a couple minutes, raise any issues with the HOA. You do not want the board meeting, the minutes to also kind of be a reflection of everything that was brought up during homeowner forum. I think if there are any items of note, you can note those, take note of those and see if you need to look into those. But every single item and what the complaints were and what the arguments were in a homeowner forum, you don't need to go into that. Again, we want to kind of limit what's discoverable and what's going to be kind of fleshed out in litigation, should there be any litigation for the HOA. As far as the next item here, when to call legal counsel, I always say I don't want to ever sound self-serving, but and anybody who's hopefully had the pleasure of working with me knows we are very, especially for smaller associations, we're very adamant about not wanting to spend too much in legal fees. We don't want things to kind of for your associations, we're mindful of your budgets are limited. So you don't want to be spending, if you have a dispute and it's over a few $100s with a homeowner, you might not want to spend legal fees on that. it's probably not worth it. Or you might spend more in legal fees than what, kind of the monetary dispute in question is. So, I think you need to be mindful of what's really at the heart of the dispute. Has a homeowner retained an attorney? If they've retained an attorney and they're making kind of a legal demand, if there's an explicit written threat of litigation, I think it makes sense to reach out to legal counsel. Obviously, if you have questions about, hey, we're trying to figure out who's responsible for something, our CCNRs are unclear. There's a lot of little things like that that, yes, an attorney should be providing you legal advice on that. That shouldn't be management. It shouldn't be a vendor. It should be legal counsel. If you're looking for a legal interpretation on something contractually or in your CCNRs, or something an owner has raised as you guys doing illegally. But, I do think it doesn't, just because an owner maybe raises a dispute, it doesn't necessarily mean you need to go straight to an attorney. So an example would be if an owner has a complaint about something, and they request IDR, internal dispute resolution, just a meeting with the board. I don't think you should get attorneys involved. I think it should be informal. You should kind of hear it out, see if there's any progress. If they bring an attorney, and escalate it, at that point, you need to consider it. And I would say reach out to your attorney, figure that out. But I think to start a lot of disputes, I don't think you need to go straight to the attorney. Um, so yeah, I mean, I'll leave that there. But I mentioned transparency earlier about minutes. Transparency, it is key, however, in associations of, a smaller nature. So in a lot of smaller associations, and I know that there's probably some people here tonight who are dealing with this, records and transparency on kind of the historical practice of the association, it's not going to be kind of all buttoned up. And my recommendation to everybody here, or my guidance would be, technically you're not supposed to take legal advice from me tonight if you're not my client, right? So I'm not giving legal advice, but I'm trying to do everything I can. Um, my kind of advice overall is that if associations should be transparent. You have open meetings. You're required to have open meetings, unless it's a topic that's explicitly not for an open meeting. But you're required to do everything in open meetings. You're required to maintain minutes. You're required to maintain records, and there's a list of records that you're required to maintain under the Davis-Sterling Act. And that list is explicit. It's set forth in writing in the statute. So if you haven't been doing that, you need to make efforts now to do so. And really it's about complying with the statute. So yes, you should all be maintaining records. You should be acting transparently. I don't think you need to disclose things that you're not supposed to disclose. That doesn't mean that you're not being transparent. So I just think you need to kind of act as the statute requires you to act. And I say that because you don't need to assume duties that don't exist. You don't need to create obligations when they don't exist under the statute. You don't need to go above and beyond when the statute doesn't require you to. So it's not about being shady or lacking transparency or anything like that. It's really just, hey, the statute sets forth what we're supposed to do, and we're going to comply with that. And if people are seeking more or asking for more, I don't think you need to go beyond that. Could there be an instance where it makes sense to help maybe resolve something? Maybe, but that shouldn't be the norm. So I think that's important to keep in mind. And I mentioned board meetings, by the way, just to end this kind of point. Most board business is conducted in open session board meetings. So, even, I get a lot of questions about, well, we're discussing, a contract. Well, you're allowed to discuss certain contractual things in executive session, but the approval of most major items, including contracts, that should occur in an open session. And, you also have to, if you understand the list of records that homeowners are entitled to, it might help you understand that owners are entitled to request a lot of records from the HOA. And that includes contracts, that includes insurance information. So a lot of things, financials. So, unless there's kind of a sensitive topic at hand that requires, the board to meet an executive, you're going to be discussing these things in open session. And at the end of the day, owners are going to be entitled to request a lot of this information, from the HOA anyway through record requests. So keep that in mind. These are all guardrails that will help your kind of associations, which are smaller in nature, that might not have had the historic compliance statutorily with records and minutes and all of that. This will help you going forward.
Awesome. Yeah, just like a quick comment there for me. For us, I think we do provide like a digital record keeping so that, if someone, whoever needs to request or document, so that I think we provide a good portal so that all the governing documents, financials, whatever the homeowner needs, will be in there. So it'll be easy access for the, whoever needs it.
Yeah, that's good. That's good to know. Yeah, a lot of times you can just direct an owner to the portal, and a lot of the information they're seeking through a formal request will be there. So that is good to know. Okay, maintenance. This is one of the end all and be alls of HOAs, especially smaller HOAs, smaller associations. But this happens in every association. By the way, I represent associations that are 2 units. I represent associations that are 2,000 plus homes or units. So, and everything in between, and commercial and mixed with residential, purely residential. So everything across the board. And this issue about maintenance and who's responsible for what is one of the true kind of consistent across the board issues that apply almost equally. It's a great equalizer. It applies in every association. And the genesis of most maintenance issues, or lack of kind of understanding of responsibilities, is due to governing documents being poorly written. And, many associations, you know, um, especially in SoCal, and I assume most people here attending are from SoCal and Los Angeles area, but, many buildings and developments we're aging. And, a lot of developments were constructed in the 60s, 70s, and 80s. And, the 80s is almost 50 years ago now. So we're getting there, which is, that's tough for me to say out loud. But what it results in is having older governing documents that are outdated, in many cases that predate the Davis-Sterling Act, which deals with maintenance for HOAs, and just predates the adoption of most laws governing HOAs. A lot of times you open up a set of CC&Rs, especially for condos, and you just have very standard language. The owner is responsible for their unit, including all the interiors. The HOA is responsible for the common areas, and it doesn't really give you much else. I can't tell. I would say 8 out of 10 CC&R documents in LA. That's how they read. Sometimes you might get a little bit of language on exclusive use common area, but you often might not. So this is the genesis. This is the root of all the problems with kind of all these maintenance responsibility disputes. It's just the CC&Rs are unclear. So what do we do with that? Well, you need to understand your governing documents first and foremost. And one thing I like to illustrate as an example is your governing documents are the key, because the Davis-Sterling Act, which governs HOAs, it defaults to your CC&Rs. So the Davis-Sterling Act says owners are responsible for their units, HOAs are responsible for the common areas, owners are responsible to maintain exclusive use common area. HOAs are actually responsible to repair and replace exclusive use common area. And that all defers to your CC&Rs. So all of that said, your CC&Rs can provide anything else otherwise. So in a nutshell, if your CC&Rs assign a maintenance responsibility to an owner, then that's what you go by, regardless of what the statute says. So it's really important to understand that kind of default. But again, the default in the statute says what it says, but it defers to your CC&Rs. The clearer your CC&Rs are, the less, kind of issues you're going to have. Now, most condos or all condos have a document in addition to the CC&Rs called a condo plan. The condo plan lays out the boundaries of the units, and usually there will be notes in it that say the boundaries of the units are X, Y, and Z. And usually that's the interior surfaces of the walls, windows, doors, ceilings, floors, and all the airspace therein. That's like 9 out of 10 times what the condo plan is going to do. And that's what 9 out of 10 times what it's going to say specifically about the boundaries of a condo unit. So as a condo unit owner, usually, not all the time, but usually you own just the interior airspace of your condo unit. You don't own the structure, you don't own the drywall in most cases. You own what's inside the surfaces and inside. And that that's important to know because then when you look at the CCNRs and it says the word unit, you really know what it's talking about. So that's why it's important to understand what the boundaries are of your units based on the documents. Um, and then that will help you understand who's responsible for what when the CCNRs say whatever they say. And I always use this example, which is townhomes. The word townhome is not a legal term. It's not known in the law. Realtors might use it. Your documents could even use it. The name of your HOA might even have the name townhome in it. But the law governing HOAs does not recognize townhomes. So, townhomes are either going to be condos or they might just be a home in a planned development. And if you have a townhome in a planned development, that means it's sitting within a lot of land. That means the owner actually owns the structure. But if it's the townhome is a condo, that means you probably own the interior airspace. You probably don't even own the structure, which means the maintenance responsibilities are going to be wildly different if it's a condo versus a planned development. And there are many HOAs on streets in LA where you would say, well, those have to be condos. Those are attached units, townhomes, attached style townhomes. But when you actually look at the documents, the developer created them as a planned development, and the owners actually own their structure. So there's wild ranges of difference in what governing documents will do and what developers have done from the outset. So really important to understand some of those distinctions. That also feeds into the insurance. What you own as the owner might dictate what you insure, or what you're responsible for. It could compete with what you insure. So again, all of this comes from the CCNRs. Your CCNRs might have insurance language that says the owners are responsible for insuring, everything in their unit. Well, again, then it really is important. What is the boundary of the unit? What is the definition of the unit? It's really important. In most cases, you want the maintenance language to kind of correspond to the insurance language. So if you as an owner are responsible to insure the inside of your unit, then you also maintain the inside of your unit. It's aligned. Now, what if the HOA insures the inside of the units? Which is not uncommon. A lot of associations have what we call walls-in insurance coverage, where the insurance actually covers interior components and fixtures, like built-in cabinets and vanities and other components inside the unit. But as an owner, you're responsible to maintain those components because they're inside your unit usually. So what do you do when that's competing? Well, you need to look at the CCNRs. You need to maybe address that with your professionals like legal counsel or management or your insurance agent. But they're not the same thing. What the HOA is responsible to insure through its insurance policy isn't the same thing as what the HOA has to actually maintain or repair. So we might, as an HOA, be responsible to issue insurance proceeds that we get from an insurance carrier when there's a big water leak, a big claim. We might have to issue out proceeds, but it doesn't mean that we actually have to do any work in your unit. We might just issue the proceeds and then it's on you as the owner because the proceeds are covering items that you have to maintain and repair because they're inside your unit. So again, this kind of depends on what your documents say. And if your documents don't really say anything on this, then you should probably adopt some kind of policy or set of rules that lays out how these kind of things should work when there is maybe an insurance claim and who's responsible for what. So it might be good to have that kind of guidance laid out in your governing documents. And even if you can't get everything in the CCNRs, it's really helpful. It's better to have it in the rules if you can't get it in the CCNRs through an amendment. You want it somewhere. You want to be able to make the argument and take the position that we've adopted certain guidelines. So that's kind of important to consider as well. CCNRs are always considered more enforceable because they're recorded in the county. And everybody in the world is on legal notice of it because it's recorded, because the document's recorded. Rules are unrecorded. So rules, they're kind of generally viewed as not as enforceable because they don't really technically run with the land itself because they're not recorded. They're still enforceable, but the rule of thumb is that if you're going to do something that impacts what an owner can do inside their unit or that impacts the use of their unit itself, that should try to get in, you should try to get that into the CCNRs through an amendment. If it's a common area rule or kind of general community rules, um, then it can make its way into the rules. And then you don't have to go through a secret ballot vote through an amendment. So that's kind of the rule of thumb with CCNRs versus rules. But if you're unable to get something in the rules, you should have a conversation with your attorney and say, look, this is critical for us. Is it enforceable if we want to put this in our rules? Will it be enforceable? You should have that conversation. And if the answer is yes, then you should probably seek that out.
Awesome, Cyrus. I think, like you were saying in the beginning, it's really helpful for everyone to understand the governing documents, especially the CCNRs, just to understand how the community works. And that said, if any board members, if you guys have any questions, feel free to put them in the chat. There's a Q&A button in the bottom, so feel free to ask them while Cyrus goes through the presentation.
Yep. Okay, so shifting gears and a little bit related, which is maintenance. One for most communities, condominium projects, where an HOA is responsible for balconies, which is going to be almost every community where there are balconies. Even townhomes that have balconies, if that townhome is a condo, it's likely that under the CCNRs, the HOA is going to be responsible for it. And I know, and I should actually, this kind of ties into the last slide. I should mention this explicitly. Exclusive use common area. A lot of balconies are considered exclusive use common area. I do want to say something about this. There's a lot of misconception or misnomer. There's a lot of misnomers out there about who's responsible for exclusive use common area. Under statute, if something is exclusive use common area, it's the HOA's responsibility to repair and replace it unless the CCNR say otherwise. And that applies to things like balconies, windows, patios, exterior doors, like front doors of the units. All those kind of components that I like to say are in between the common area and the unit. They form the boundary of the unit, but they're in between. The front door of a lot of condo units, the front door is not inside the unit, really. It's not inside the space. It forms the boundary. It's on the boundary. So under statute, the HOA is responsible for that. If that's not consistent with your practice, you need to look at your CCNRs, see, you kind of need to maybe reconcile that. But the reason I'm mentioning this is because balconies are usually considered exclusive use common area. Even when they're not, even in some cases where like a balcony might be on the deed, it might be deeded to an owner, like a parking space might be sometimes. The actual structure of the balcony is still not the owner's. That's not really belonging to the owner. It's the airspace. It's the use of the balcony that's really deeded to an owner or exclusively assigned to the owner for their exclusive use. It's the use of it, the airspace of it. It's not the structure. So, that comes up a lot. And in most HOAs, the HOA will be responsible for the structure. Because of that, there is statute, and based on a really popular bill, a few years old now, that mandates that HOAs perform balcony inspections. It was supposed to be done by January 1st of this year, so that's passed, as well as every 9 years. This balcony inspection is going to yield a report, and this report is going to be a part of your reserve study, which is a study that you'll have done by a professional reserve preparer to understand the useful life of all the major common area components in your community and how much you should be contributing towards a reserve fund so that over time, when issues come up with these common area components, you're able to address those repairs. So you're not left with no money in the reserves and an inability to fund without an assessment. Now, you still might need to levy a special assessment to maybe replenish your reserves or just maybe kind of work in combination with your reserves to maybe fund a project. but you need to be doing these inspections because they are going to be a part of your report and they're required statutorily. These were required by January 1st. If you haven't done one yet, um, the best guidance I can give is just do it. Comply. Technically, you're not in compliance with the January 1st date. Does that necessarily mean you're in trouble? No. I mean, the statute doesn't really go into what happens if you haven't done this. So I just think you need to comply as best as you can, especially once you're aware that this condition, that this requirement applies to your community. And so I think that's really important. These reports, technically speaking, the inspectors who perform these reports, which are going to be licensed structural or civil engineers or architects, um, they are directed by statute to actually communicate directly with the city or the governmental agency or building department if there are items that are critical in nature. Um, they're actually directed to do that without any approval of the association. So, these are important. This is all born out of the Berkeley balcony collapse several years ago. That's where all of this comes from. And basically, it's going to apply if you have wood-based balconies or other components that extend outside of the envelope of your building, over 6 feet high and above ground. And so this definitely is going to apply to balconies. It could apply to certain types of patios if they're above ground. Could apply to certain stairwells. There are certain like walkways where this could apply. Again, if it's wood-based construction. So um, I would just say comply with it. And what we're seeing now is that lenders and realtors and sales and escrows and refinances, all of them are basically requiring um, any reports or recent inspections performed by the association of a structural nature. And the reason lender questionnaires are going into that is because of the condominium building collapse in Florida, Champaign Towers in Florida. When that occurred a few years ago, basically the government kind of reconciled and kind of evaluated all of their lender questionnaires and requirements for Fannie Mae and Freddie Mac, and all of those questionnaires are kind of adopted by all lenders. All of those kind of guidelines are adopted by all lenders because they want to make sure that they're kind of compliant with Fannie Mae and Freddie Mac guidelines. So that's why any lender questionnaires you're receiving or requests you're receiving are going to be seeking structural inspections, they're going to be asking about structural integrity, including the balcony reports. Technically speaking, a balcony report is a part of the reserve study, which I said a minute ago. Therefore, it's an HOA record under the Davis-Sterling Act, meaning it has to be disclosed to a member. And that's whether or not there's a lender seeking it or a questionnaire. Even if a member requests it, they're entitled to that report. Other structural reports are not technically a part of the reserve study. So you're not technically required to disclose a report of a structural nature that's not a balcony report under SB 326. Now, that that's all good and well. And I said earlier, don't do things you're not necessarily required to do. But if in your community, you're not going to be able to get financing if you don't provide structural reports that the lenders are requiring, then you're potentially kind of not interfering, but you're potentially kind of impacting the practical kind of saleability or kind of the refinanceability, alienability of properties in your community. So important to keep that in mind. That's a discussion to have with your attorney. Hey, they're seeking a specific report. It's not an HOA record. Should we disclose it? I think most attorneys will probably say, if this is just going to impact all of your financing decisions in the community, you should. But keep that in mind. And then the last thing I want to say on this is, actually doing the work. It's one thing to get a report on SB 326, but then you have to do the work. And I think the nature of the work will dictate, the nature of the scope of the work will dictate, is it an emergency assessment or is it a special assessment? Do you need to get a homeowner vote? Is it cosmetic? Or is it structural? Are there structural concerns? Are there hazardous conditions? Are there life and safety concerns? In which case, could we invoke a potential emergency assessment where you do not have to go through a vote of the members because there is a statutory exception that says you don't have to do so? And that's something that's defined under statute. So these are things to keep in mind and have these discussions on if you are undergoing this process. You do always have to disclose any anticipated special assessment. So that is something to keep in mind. You can't, mislead owners when there is something anticipated. But what does it mean to be anticipated? Like how speculative does it need to be? Hey, we know we have to do balconies next year. Uh, does that mean we're anticipating a special assessment yet? That might be too speculative if that's all you know. You might need to get some tangible kind of figures. You might need to bid out first before you go this route, before you actually disclose anything. So again, these are conversations to have with management and maybe more so with your legal counsel.
Yeah, Cyrus, I think it would be actually really helpful if we could kind of go deeper in when does an assessment qualify as emergency?
So under statute, there are three circumstances where you can levy an emergency assessment. Number one is when there's a court order. So I'm not going to talk about that. Court order or court orders you to do it. Okay, easy, enough said. The two situations that really matter are when there's a threat of safety discovered on the property, or there's a hazardous condition discovered on the property. So that's where, whether it's maybe there's a potential for water intrusion issues, maybe there's a potential for there's a structural concern. There are various types of, threats of safety or hazardous conditions. I feel like there's a lot of that can be interpreted in a lot of ways. And I think leaning on your experts, which is your legal counsel, and the actual experts, like the structural engineers or the civil engineers or the architect or the vendor, the contractor, whoever it is, that's where you really need to rely on to see do you qualify for that exception? Threat of safety or hazardous condition on the property. The other kind of statutory exception or prong that you can invoke is when there's an unforeseeable expense that couldn't have been budgeted for when you did your budget for the current year in which you're levying this assessment. So, a good example of this that's come up a lot recently is all of a sudden you get word of a significant exponential increase in your insurance premiums because a lot of associations' insurance premiums are skyrocketing. Let's say you get that next month. You didn't budget for it, and it was unforeseeable, extraordinary expense, and that could potentially that would qualify, I think, under that exception. And as long as you didn't budget for it and it was unforeseeable, there's a good chance you're going to be able to invoke that as well. Now, there's some procedure if you're going to go that route, but that the board would have to undertake. But those are the exceptions, which I think a lot of communities can justifiably rely on, given kind of a lot of the current situations that are happening with insurance premium increases, things that are coming up out of the blue, structural, you get a report and all of a sudden you find out that there's something really significant in nature, maybe water intrusion situations with heavy rains, whatever it is. So there's a lot of flexibility there. If it's truly just, hey, we need to repair something, but it's not urgent. We've known about it forever. That could be a problem if you try to lump that into an emergency assessment.
We just have a quick question from a board member. Are patios and balconies would they be considered the same?
Say that again.
Are patios and balconies considered the same, or maybe this board member is asking for the SB 326?
Yeah, usually patios are not considered subject to the inspection. Usually patios are not above 6 feet above ground. Now, your documents could call something a patio, but what you really need to focus on is is the whether it's called a patio or a deck or a terrace or a balcony, is it over 6 feet above ground? And is it wood based? A lot of patios are slab based. They might be concrete, and so not implicating wood based construction. So I think that's so I'll say the answer then. The best answer I can give is usually, generally speaking, patios and balconies are different. Patios are usually kind of first level, a ground level or first level above a garage, and balconies are kind of considered everything upper level. But regardless of the term you use, is it wood-based construction, and is it 6 feet above the ground, and is it extending outside of the envelope of the building? Some patios and balconies are inset, where it's not even extending outside of the envelope of the exterior wall of the building. So, you wouldn't even have to, consider those as subject to the inspection potentially either. So hopefully that answers that. Yeah.
Awesome.
Okay, I've already touched on like non-SB 326 reports, so I'll kind of skip over that now. I know we only have a few minutes left. Last thing I wanted to touch on was insurance. And, I touched on it briefly, but when I mentioned that a lot of premiums are rising. But insurance is kind of the perfect storm right now. And it's not all just because of fires in California. There have been fires in Colorado and Texas. There have been other natural disasters in other parts of the country. There's also just other issues. Buildings, most buildings they're aging. So, carriers kind of understand that the risks are greater. Um, so there's a lot of reasons for increasing, insurance kind of costs. Also, by the way, materials and labor and all those things are rising. So when they're factoring in what it costs to actually insure a building, and what payouts might be, they're factoring in that costs might be higher now. So, just all of this is kind of, like I said, creating this perfect storm of increasing insurance costs. And what that means to all of us is that we're seeing a lot of unforeseen, even though we all kind of understand, I'm talking about it today, but it's still unforeseen when it actually hits your association. And let alone if you have one or two claims in a year. I mean, I have many associations that are losing their insurance or getting exponential increases without claims being filed. I can tell you from my personal home, I was non-renewed for my own insurance without any claim, and that's because I'm somewhat in a fire-related area. Um, but so it's a big deal. It's harder for HOAs to maintain insurance than it is for homeowners to maintain insurance, um, despite what I just said about myself. And that's because HOAs maintain commercial policies. These are master policies. They're difficult to maintain. Like I said, one or two claims could really, impact the insurance, if not lose it for you. So why am I saying all this? I think associations need to consider, looking at their CC&Rs, understand what their documents say, what their coverages are. Um, if HOAs are insuring the inside of units and you have claims or you have water intrusion or leaks or floods and it impacts the inside of a unit, an owner's insurance probably won't cover it because the owner's insurance is going to look to the CC&Rs and say, hey, the HOA covers everything inside the unit. And you're going to see that a lot. And that is happening a lot, because these carriers are going to try to default to the CC&Rs, especially when the CC&Rs say that the HOA insures anything inside the units. So understand your policies, understand what your CC&Rs mandate, and if your CC&Rs mandate something that you don't want, in most cases, walls in insurance, um, you might want to consider changing that through an amendment. Um, you know, a lot of older documents have walls in policy, walls in language, because that was before lenders for individual homeowners started really mandating that owners get their own policies as a condition of a loan. So before that really started kind of taking effect, so kind of vociferously now, just kind of so kind of across the board as kind of standard operating procedure in the industry. That's why a lot of older documents have that kind of standard. So if you have documents from the 80s or early 90s or certainly anything before, there's a good chance that your documents will be kind of vague. And if they're vague, there's a good chance that that insurance carriers are going to say that means we insure the entire development, including what's inside the units, except for owner personal property, like truly personal property. So really important to understand that. In some cases, I've had some associations say that they couldn't get renewed or that they had to specifically amend their CC&Rs in order to get insurance with a carrier. And so I've helped a lot of associations make changes in language in order to make sure that the language was appropriate. As far as framing this, there's nothing to hide. You know, if an owner doesn't like that an HOA wants to kind of whittle away its insurance coverage to be more common area focused and not unit focused, you know, you can sell it, I think, pretty easily. If the HOA loses its insurance, that's a nuclear situation for an HOA. Nuclear. The HOA is mandated to insure the common areas. So, you know, not doing so would be nuclear. Having really bad insurance could be very problematic, highly problematic. And, you know, insurance is going to really constitute a significant portion of your assessments, your monthly dues. And if you can limit claims, then theoretically you're not you're minimizing, you're not maximizing, you're minimizing the extent that your insurance is a part of your HOA assessments. We want to keep that as much kind of as kind of as mitigated as possible so that if your assessments are going up, it's not because of your insurance. There might be other factors you can't control, like wages that are increasing in the state, or you know, utility costs going up, therefore your water costs go up or your electricity costs go up. But insurance is something that you don't want to contribute to the increase. So that's what a lot of associations are doing. And so I wanted to kind of comment on that the insurance crisis and kind of what we're seeing. And I did comment, by the way, that um, there are some attorneys who I think have different views on this. My view is that if you have an emergency, if you have an increase in insurance and it's significant and unaffordable and it's something that you didn't budget for, I think that could give rise to an emergency assessment. But you know, I'll always say that if that's happening to your association, like actually reach out to your attorney, get a real opinion on it. And I say that because if you get an actual opinion from an attorney, you can't just listen to what I say during a webinar and say, that's what we're going off of. If you get an actual opinion in writing from an attorney, you are protected as a board. It means you've exercised your sound business judgment because you relied on an expert, and therefore the board is protected. Even if you make a wrong decision, you're protected. Somebody could sue you. A court could say, I actually like the owner's argument, not the HOA's, but the board will still be protected because you relied on the experts. So that's really important, is rely on your experts in making all your decisions. So I
Awesome.
think, yeah, that kind of leads us to any questions, Simon. I don't know if there were any others or if there's just anything general you
Yeah,
wanted to
I
discuss.
think a lot of the questions that we usually get is, what should we do if the governing documents are severely outdated? What is like the first step that the board members should do?
Well, there's a few options. Number one, let me say this. This is kind of a initial disclaimer. You don't have to change, and I should give this disclaimer as well. A large part of what I personally do, my practice, is I restate governing documents. I prepare new governing documents for HOAs. That's a large part of what I do. I oversee my firm's program for restating governing documents. So it's kind of a passion of mine, or it's a big part of what I personally do. With that said, you don't always have to amend or restate your governing documents simply because they're outdated necessarily. Just because you might not be in compliance with the law, the law doesn't say that if you have outdated CC&Rs, you have to amend them. The law doesn't say that. So I do like to point that out. However, if your documents are outdated, you're probably suffering from a lot. You're not taking advantage of a lot that could protect your association legally and financially. So what should you do? You should get a proposal from firms. My firm does it. A lot of firms do it. You should get a proposal. What does it look like to update our governing documents? Um, and should that update be full in nature? Should we update everything, the entire document? Or is it just a single provision? Or is it one section? What's most important to you? Like if you have no issues and your maintenance language is for whatever, even if you have outdated documents, let's say you have somewhat clear maintenance language in your CC&Rs and you have somewhat clear insurance language, and the only thing you really care about is rentals. Well, you might not need to update the entire document. You might only want to change one thing. Or let's say you want to change the number of people who serve on the board. You might not need to change the entire set of bylaws. You might just want to change one provision for now. So I think that's kind of the first conversation, but you should reach out and get proposals on, hey, what does it look like to maybe change one thing? And here's what that one thing is versus the entire document. I can tell you that once you start getting kind of multiple in number, like, hey, we want to change these four things, you're probably getting into the thousands of dollars already. And at that point, it probably makes sense to just redo your entire set of governing documents, because it wouldn't be cost effective to just change a bunch of items piecemeal. So I think that's the first kind of question. But yeah, if your documents are outdated, explore updates and within that, whether it should be a single kind of spot amendment or a restatement of the entire set of governing documents. I think that's kind of first and foremost. And then one other thing I'll mention is some communities, explore. I said this earlier, hey, we know we can't amend our CC&Rs for whatever reason, or it's just not successful, or we're trying and it's not successful. We can't get the vote, blah, blah, blah. What about our rules? Can we do anything through our rules and then explore that as well? Some communities, they like to get a maintenance matrix, which is like a chart that explains who's responsible for everything from a maintenance standpoint. Uh, that's something we do as well, but that can get kind of expensive. And if you're amending your CC&Rs, you might be able to just amend your CC&Rs and include a matrix in your CC&Rs and actually change things that you want when you're actually amending your CC&Rs. When you're preparing a matrix without amending your CC&Rs and you're just doing it kind of in your rules, you can't change what's in your CC&Rs. That's basically an attorney summarizing what's in your CC&Rs in a chart-like format. So there are differences in that as well, but that's also an option.
Awesome.
Yeah.
Very helpful. Just to respect everyone's time, unfortunately, that's all we have for now for this webinar. Thank you, Cyrus. Thank you so much for this, an hour of really great advice for just our HOAs and just really helpful information such as the AB 130. And thank you, everyone, every board members, for joining us. We'll keep you guys updated for our next webinar. Anything else, Cyrus? I think you have your next slide is your information.
Oh, yeah. So I guess the last thing I'd say is if you have any questions, you could reach out to Simon and he could, if you have like a general question, you could reach out to him. My info is here as well. So, if it's very specific in nature, and I would need to look at things, I might not be able to answer a question generally, but I like to kind of give help wherever I can. And if you're looking for something specific for your association where we could really help you, like obviously reach out. We're happy to, assist anybody. But if there's just anything general in nature, my info is here, and then you could reach out to Simon, and I'm sure he would. He's busy, but I'm sure he wouldn't mind relaying anything to me either. So I just appreciate everybody's time tonight. You being here shows your commitment to your associations. We all joke about, you guys, you're not getting paid enough to be on HOA boards. But yet you're taking on all of this kind of stress and even risk and liability and all that. So the goal is to limit your liability and just protect you. So, we're here to do that.
Awesome. Thank
Yeah.
you, Cyrus. Thank you,
Okay.
everyone.
Thanks, everyone.